NJCJI has been sounding the alarm on TCCWNA for several years now. It's only recently that we've seen it really taken advantage of by some members of the organized plaintiffs' bar, present company Joe excluded, I think mostly. But in the last 10 to 12 months, in particular, we've seen a real dramatic spike in class actions alleging TCCWNA violations. And today our panelists are going to talk about the causes and the consequences of that spike and those lawsuits and some potential responses to them, largely focused on legal arguments to make in favor, in Joe's case, and against in the case of the remaining panelists. So let me start by introducing myself. As Marcus said, I'm Ed Fanning. I'm with McCarter English. I've been there for 22 years, the entirety of my career in the legal profession. I'm here today, and I'd be remiss if I didn't mention the other members of our TCCWNA task force, as we've called it, and they include my partner David Cott, who's seated here at the McCarter table, who's a board member here at NJCJI, Greg Horowitz, who, unlike David and Zane and myself, is not a class action litigator, but rather an insurance coverage lawyer who represents policyholders, companies who seek coverage for various types of claims, including TCCWNA claims. And Greg has actually had a fair amount of success in favor of our clients in the TCCWNA area in obtaining insurance coverage that would include payment of defense costs and in some cases, indemnity obligations. Beth Monahan, who's also seated at the McCarter table, who is truly the brains of our operation. And then I'll introduce my partner, Zane Reister, the handsome fellow with the beard over there, who is also in the product liability group at McCarter English. Zane is a graduate of Fordham University School of Law. He, as well as our TCCWNA team, are representing currently 3 separate defendants and 3 separate class actions pending here in the District of New Jersey. Zane and our team also represented the New Jersey Symphony Orchestra in a TCCWNA class action that was filed against them earlier this year, but dismissed in the face of a pre-answered motion to dismiss that case. So we, as Jeff mentioned on the earlier panel, we're waiting for decisions in the other matters. In addition to his involvement in defending TCCWNA litigation, Zane has also been very deeply involved on behalf of dozens of our clients, literally, in making amendments, adjustments, tweaks to their websites to deal with potential TCCWNA issues, to clarify things in website terms of use, terms and conditions, to hopefully lower our client's profile for these kinds of lawsuits. So he has a specialty in that area as well. Our next panelist is Joe Fischetti from the Lowenstein-Sandler firm. Joe is pinch hitting for Gavin Rooney and is the better looking version of Gavin. So welcome Joe. Joe's a graduate of Seton Hall Law School, magna cum laude, where he was editor of the Law Review. He did 2 exceptional clerkships, one for District Judge Catherine Sweeney Hayden here in the District Court in New Jersey, and then for Chief Justice Stuart Rabner of the New Jersey Supreme Court. Joe, as I said, practices at Lowenstein, where he focuses on representing clients in any number of commercial litigations and class actions, including consumer protection class actions and financial marketing litigation. You've already met Jeff Jacobson, who's seated at this end of the dais.
I can have an opinion on this panel.
Jeff, as you were told, is a partner at Kelly Dry in Parsippany. And before that, he spent 2 years at the Attorney General's office, at the highest levels of the Attorney General's office, as director of the division and then as counsel to the Attorney General, chief counsel to the Attorney General himself. So Jeff has the unique perspective of having been essentially both a plaintiff's lawyer and now a defense lawyer as it relates to various consumer protection issues, and will give us his perspective on those as well. The plaintiff's attorney member of our panel is our friend Joe DePalma, who's seated at the far end of the dais. Joe is a graduate of both Seton Hall University and Seton Hall Law. Does that make you a double pirate, Joe? Did you go to Seton Hall Prep too?
Seton Hall Prep as well.
You did? So did I. We have to talk about that. But so that makes you a triple pirate.
Absolutely.
Well, congratulations. So Joe is a co-founder and managing member of Light DePalma and Greenberg in Newark, which is truly one of the premier plaintiffs firms, not just here in New Jersey, but also in the United States. In his class action practice, Joe represents plaintiffs in any number of different areas, whether it be product liability, antitrust, securities, ERISA issues, and also certainly consumer fraud and consumer protection issues. Joe himself has personally negotiated a number of landmark class action settlements, including 2 of the top 50 national securities class action settlements and 1 of the top 5 accounting settlements in the nation against one of the big 4 accounting firms. Joe is currently involved in any number of nationwide class actions pending all around the country as we sit here today. We have, not in paper printed out form, but there are a number of handouts that I just want to direct your attention to. If you registered ahead of time, you received an email that had links to various attachments, including the TCCWNA statute that we're going to be talking about here today, the Assembly sponsors statement and Assembly committee amendments to the statute, which Joe is going to talk a little bit about in a moment. A recent decision from our state court appellate division in a case called Smerling versus Harris, a very recent decision actually out of the Central District of California, so federal court in California, in a case called Candelario versus Rip Curl. 2 different publications that Joe Fischetti and Gavin Rooney were involved with from the Lowenstein firm, involving a case called Spokio, which we're going to talk about here today, and also TCCWNA issues generally, certainly as they apply to website terms of use. You also have in those materials a McCarter client alert from our McCarter team here today concerning TCCWNA and its focus on online terms of use. One thing you don't have in your materials here today, but only because it is literally hot off the presses, is a 3-part series that the McCarter folks published in the New Jersey Law Journal discussing potential constitutional challenges to TCCWNA, focused on the lack of an intent requirement under TCCWNA, focused on the lack of an injury requirement potentially under TCCWNA, and concepts of proportionality of penalties potentially imposed pursuant to TCCWNA in the absence of an intent requirement and in the absence of an actual injury. So equal protection and due process arguments that may one day be asserted in the face of TCCWNA claims. So I'm going to start in just a moment with Joe DePalma, who I'm going to ask to give us an overview. Not everybody in the room is a lawyer, and we're going to give you an overview of what TCCWNA is all about, essentially focused on what TCCWNA was intended to accomplish. We'll then touch briefly on some of the unintended consequences, more from the defense side of TCCWNA, including the spike in recent cases that I mentioned to you. And then we'll get into a discussion of various legal issues that these TCCWNA class actions present. I would encourage all of you, not just Alita, to ask questions during this panel. So please feel free to raise your hand, and we'll be happy to get you involved in what I hope will be an interactive discussion. So with that, Joe?
Thank you, Ed, for those kind words. I'm happy to be here today to provide a plaintiff's perspective on TCCWNA. I'm also going to talk about what it was intended to achieve and whether it has succeeded. It's important to start with this principle. TCCWNA has been held to be a remedial statute. And like all remedial statutes, it's intended, the court is to give broad interpretation to facilitate its stated purpose. That purpose, of course, is to root out consumer fraud. In Shelton versus Restaurant.com, a case that Mike McDonald referred to, he had represented Restaurant.com. My partner, Bruce Greenberg, represented plaintiffs in that case. The court there spelled out the purposes behind the TCCWNA. And it remarked in that case that it's intended to strengthen the Consumer Fraud Act. What's important is that the act itself does not create any new consumer rights. Instead, it imposes obligations on sellers to acknowledge clearly established consumer rights and to provide remedies for posting and inserting provisions that are contrary to clearly established law. There's a lot of debate about what TCCWNA is supposed to apply to. We're going to talk about whether you have to be an aggrieved consumer, meaning that you have to have established an actual loss or not. There's a lot of issues we're going to discuss. But let me start with this. The wrongs that TCCWNA sought to end include the inclusion of unfair terms that appear to be enforceable, but they're not. So it's the mere inclusion of terms that gives a plaintiff a right to a cause of action. And that is clearly spelled out in the materials that you have online. The Assembly Commerce Committee statement dated June 9th states that even though provisions are invalid or unenforceable, their very inclusion in a contract, warranty, notice, or sign deceives the customer into thinking that they are enforceable, and for this reason, the consumer often fails to enforce his rights. So we're going to talk about a lot of issues. We're going to dive very deep into constitutional and statutory standing, whether Spokio forms an Article 3 barrier to a plaintiff in federal court. We're going to talk about statutory standing, what the meaning of an aggrieved consumer is, whether a website's terms and conditions constitute a consumer contract such that it falls within the Act, and many more. But before we get into the weeds, I want to give you that overview. So there's only 4 sections of TCCWNA. There's 2 that set forth what is prohibited under the Act, sections 15 and 16, and there's 2 sections that talk about remedies, 17 and 18. So the cornerstone of TCCWNA is section 15, and it has 4 elements. So to state a claim, we're drafting a complaint for a plaintiff, we have to establish these 4 things. We must allege that the plaintiff is a consumer or a prospective consumer, and that or is very important. A consumer or prospective consumer, that the defendant is a seller, lessor, creditor, lender, or bailee. Number 3, that the defendant offers or enters into a consumer contract, or gives or displays any written notice or sign. There's a lot of ors there as well, and they're all important. And 4th, that the contract, notice, or sign contains a provision that violates a clearly established legal right of a consumer, again, or a responsibility of the seller. So, to me, it's very clear that the legislature crafted this law to apply to conduct that occurs before a contract is executed. Otherwise, it would never have used the word offer. And it applies before a prospective consumer becomes an actual consumer. And we'll discuss these concepts when we swing back around and talk about the Harris case, because the appellate division there just very recently wrote the word offer and the term prospective consumer out of the statute in holding that TCCWNA does not apply because the plaintiff there was not a consumer. So that's section 15. Section 16 has 2 components. The first one is not controversial at all. It basically says that if a consumer contract or warranty or sign contains a provision where a consumer waives his rights under this act, it's null and void. But the real controversy is in the second component of 16. And it states, no consumer contract, notice or sign, shall state that any of its provisions is or may be void in New Jersey, or in some jurisdictions, without specifying which of those provisions are or are not valid in New Jersey. And this section has given rise to a lot of the website cases that I think we're going to talk about in a bit. Now we shift to remedies. The violation of either one of these sections gives rise to penalties and damages. Section 17 says that the penalty shall be not less than $100 or for actual damages or both. And this distinction between a penalty and damage is very important because it's going to inform our discussion on whether a consumer needs to have actual damages. Does the term in the Act, aggrieved consumer, mean that somebody has to allege that they actually suffered a monetary loss or not? I think not, and the reason is because the Assembly Commerce Committee statement that's in your materials, it's dated June 9th, says the following, that this section provides that a business which violates the provisions of this bill would be liable to the aggrieved consumer for a penalty of not less than $100 if the consumer was not injured by such violation and for a civil penalty and actual damages if he was injured by the violation. I think that speaks loud and clear to what the statute means. And then finally, Section 18 says that any of the rights, remedies, and prohibitions in the TCCWNA are cumulative to other laws. That's the general overview of TCCWNA. There's in the handouts, you'll see the sections. We're going to refer back to them when we talk about the Harris case. Has it succeeded? Well, as Ed's going to speak to in a moment, and as you've heard before, it's been a rather sleepy statute in its early years. It was enacted over 30 years ago, and it wasn't until recently that there's been a lot of focus on the TCCWNA. So to me, if success equals awareness, then it has been successful. It's gotten the business community interested in what it says. It's gotten people like Zane to make amendments, adjustments, and tweaks to his clients' contracts, and that's the purpose behind it, to eradicate from these writings provisions that clearly violate New Jersey law.
Thanks, Joe. So, as Joe mentioned and as Mike mentioned in the last panel, for a long time, TCCWNA was largely ignored, not completely, but largely ignored. And when it was relied upon, it was normally in the context of, I think, the traditional consumer contract that you would think of, a warranty, an actual consumer contract that somebody walking into a brick and mortar store would sign off on or see in the context of a consumer transaction in the traditional sense. What's happened recently, certainly within the last year or a little bit less, is this focus on companies' website terms of use and terms and conditions, which nearly every company has. If you have a web presence, you in all likelihood have terms of use and terms and conditions, normally buried at the bottom of the page with a link that you can click on and read them if you so desire. Very few people do, but some members of the organized plaintiffs' bar have focused on those and fashioned an argument that those website terms of use or terms and conditions, which we on the defense side, and Zane in particular has advanced this argument, think isn't really what TCCWNA is intended to address. This is not necessarily the type of agreement, if it's even that pertains to a consumer transaction rather than your use and the obligations and responsibilities that you undertake when you browse on a company's website. But nonetheless, plaintiff's bar has focused on that and alleged that certain terms in those website terms of use can violate and do violate TCCWNA. So in the last 12 months, we've seen, by our count, 65 class actions filed in New Jersey state and federal court alleging TCCWNA violations. 45 of those 65 class actions have been filed by the same 11 law firms. They, on top of that, often involve the same plaintiffs or prospective class members. We have, by our count, 8 individual plaintiffs who are responsible for 19 different lawsuits. They're obviously 8 individuals who are very concerned with their clearly established legal rights, but they are advancing these lawsuits, obviously, with the assistance of capable plaintiffs' counsel in an effort to bring forth these TCCWNA violations. And that is not even counting TCCWNA cases that are being brought outside of New Jersey. We actually have some of these same plaintiffs, including a plaintiff in a case that McCarter is defending here in New Jersey, that has filed a separate TCCWNA class action alleging essentially identical violations against a different company, but in California. That's actually one of the materials in the handouts that are available online, the Candelario decision out of California that we've provided to you. The focus of the website terms of use have traditionally been on, in the TCCWNA space anyway, on a couple of different provisions that you will typically see in a website terms and conditions. They would include exculpatory provisions, disclaimers, sometimes indemnity obligations, clauses disclaiming liability for hacking, for third-party hackers and their efforts to obtain personal data and information and then use it to the detriment of consumers. So that's the spike that we have seen recently and we think, or potentially some of the unintended consequences of TCCWNA, which, as Mike mentioned, was enacted before there even was an internet. I'd like to turn it to Joe Fischetti to talk a little bit about the standard for a violation under the Act, and in particular the operative term that is focused on, and certainly in the arguments concerning these acts, and that is, what is a clearly established legal right? Again, as Joe mentioned, in order for there to be a violation, there has to be a term in a consumer agreement or notice or sign that violates a clearly established legal right. And what does that mean? I mean, I'll ask any one of you, what does that mean? What is a clearly established legal right? I mean, Joe's going to talk about that. And the corollary to that is, what is the responsibility of a seller, which is also included in the Act itself. So, Joe, can you talk with us a little bit about that?
Sure. I think, a lot of the attention gets put on what clearly established means, but I think kind of a threshold thing to keep in mind is that a legal right, in the early cases, they were almost always statutory. It can be either a statutory right or a common law right. And right is probably, it's not something that has ever really been directly explored in what it means here, but what it can really be distilled to is, does a consumer have some sort of guarantee under the law that is being challenged through the contracts? They have a right to bring a certain kind of claim. They have a right to a certain degree of notice before an action is taken. Those are the types of things that make for rights. And so the question becomes then, what makes it a clearly established legal right? Given that it's a threshold issue, it's kind of surprising there is not actually a binding decision on what clearly established means in this context. There's an unpublished Third Circuit case that essentially has said that the right cannot be in any way unclear, and which is really just a tautology. And that case involved kind of leaning on persuasive authority from administrative guidance, and it wasn't directly on point. And so, it wasn't found to be completely clear. There is a case in the pipeline in the appellate division that might give some guidance on that we briefed with the Civil Justice Institute as amicus. As you did, we representing Civil Justice Institute, that might give some more guidance on that. The theory that we have, and that I think we're not the only ones who've argued this, it's very often argued, is that the term clearly established legal right is almost a term of art in the context of qualified immunity in federal cases, 1983 actions brought against government officials. And in that context, what clearly established means is that the right is one that would have been clear to a reasonable officer that his conduct was unlawful in the situation he confronted, and that existing precedent must set it beyond debate. That's not a standard that's been adopted to this context, but it's one that I've always thought is persuasive, and I think the bottom line when it comes to clearly established is that Section 15 would make perfect grammatical sense if you just struck out the word clearly established. You could just have it be a legal right. The fact that clearly established is there means the words must have some meaning, and there have to be certain instances in which a court could find, yes, the consumer had a legal right here, but it was not crystal clear at the time that contract was entered, and therefore there's not a TCCWNA violation. That hasn't happened yet, but I think that the language certainly requires that such an event could occur. One note is that when you're looking at cases are often easier when you're dealing with a statutory right. The statutes can often be cleaner, not always, but often. In the context of common law, you can't just rely on the idea that there is not a directly analogous factual situation that applies here. If you can take the legal principles that are clear in the law, in published decisions, and apply them to your situation, to your contract, and realize this would not be enforceable, that's going to be run afoul of someone's legal right. And of course, even if it is a question of first impression, a court can always say this was still clear based on existing principles just applied here. I do also think another important peg that gets overlooked in Section 15 because the cases rarely get brought if it's not there. But the legal right has to exist at the time the offer was made or contract was entered. And one thing as a kind of a practical standpoint is that when you're looking at revising contracts with consumers that you have already, is to be cautious to do comprehensive fixes of your statutes, because you can inadvertently bring a statute up to speed in one specific area. Say a statute's passed, and you update your statute to accommodate, you update your contracts to accommodate that statute. If you don't also take account of other changes in the law since you first entered that, you could be bringing the contract kind of within a new window where previously unenforceable but not violative of TCCWNA provisions could suddenly become TCCWNA actions. I think that,
Yeah, thanks, Joe. I'd like to get Zane involved in the discussion a little bit. And if you could talk to us, Zane, a little bit about another term that's used in TCCWNA. In the penalty section, Section 17, it talks about any person who violates the provisions of this act shall be liable to the aggrieved consumer, for a civil penalty of not less than $100 for actual damages or both. Talk to us a little bit about what that means and if there's any guidance in case law or otherwise to help us interpret that.
I'd be happy to. It's what's amazing about the statute is so much of it is undefined. We talked about a recognized legal right is undefined in the statute. Consumer contract is undefined in the statute. And aggrieved consumer is another term that is undefined in the statute, and there is very little case law on what that means. Now, if we kind of step back and think about what the statute was intended, and this is something that Joe did, it was intended to prevent deceptive conduct that impacts the rights of a consumer. So that's the intention of the act. I think to be aggrieved, you would have to have suffered some effect from the violation of the act. And that means you really can't have a aggrieved prospective consumer. And this is where I'm going to disagree with you, Joe. I don't think you can have a right of action under the act unless you have been aggrieved in some way or injured in some way. Now, whether that's a monetary injury, that might be too far. I don't think we're dealing with a situation where we have the Consumer Fraud Act where you need some sort of ascertainable loss. But I think it's more than just being a potential purchaser. So I think aggrieved consumer does have some meaning. I think if you look at Section 17, which gives you the private right of action under TCCWNA, it does talk about the private right of action being available to a business who aggrieved the consumer. And so there has to be some sort of harm. Now, what that harm is, there's very little case law. There's basically, in the 33 years we've been dealing with the statute, there's maybe 2 cases that have tried to define what that term is, and both of them have kind of fallen on that finding. There has to be some sort of harm. There has to be some sort of rights that were adversely affected, that the consumer's rights in some way were adversely affected by that language. So I think it does have some meaning. I do think there has to be some level of harm. And if you look at the Shaw case and the Cameron case, which is, I think, the only state court case dealing with what aggrieved consumer means, they both found the same thing, that if you're not injured, if you're not unhappy with the contract, if something had not, that your rights were not somehow adversely affected, I don't think you have a right under the statute.
Anybody else have another view on that?
I do.
Go ahead, Joe.
Of course you do.
An aggrieved consumer is a consumer who's been subject to a writing which contains a clause that violates the statute. If it goes beyond that, you have to start reading words out of Section 15 and 16. The Act is very clear that the writing that could give rise to a violation can be contained in a mere offer to a consumer, like I said, or a prospective consumer. So you don't have to actually have entered into a contract to have the ability to maintain a TCCWNA case. And when you start going down this path by putting too much on what aggrieved consumer means in Section 17, by necessity you have to start reading words out of Section 15. When we talk about Harris, I'll remark how the court, I think in a result-driven decision, which I think is wrong, had to do that, had to read out certain words of the statute in order to give effect to other provisions.
I'm going to agree with Joe more than I'm going to agree with my colleagues on the defense side here. I mean, I had to enforce this sucker for a couple of years, and we haven't talked about the motivation behind the statute and the specific examples that the legislature had in mind. I think it's worth talking about. The public storage firms, you store it, you lock it, you keep the key. They had provisions in their contracts that basically said, if you slip and fall on my premises, even if it's my fault, even if I should have known it was there, you're liable. And if you bring your Uncle Joe, and your Uncle Joe slips and falls on my premises, even if it's my fault, you indemnify me against Uncle Joe's lawsuit. And those provisions were not legal in New Jersey. They're not legal in many places, but they're certainly not legal in New Jersey because the Supreme Court has said so. And so here comes the legislature with a law that says, thou shalt not put in a contract that kind of provision which is unenforceable. And in the legislative history, it was as clear as a bell that they were not just talking about after Uncle Joe slips and falls. They were talking about the mere presentation of that contract to someone because they might be dissuaded from bringing a claim that they do not yet have but may have someday. They wanted that to be enforceable. Now, whether they can or can't under the Constitution, that's a different question. But the legislature intended that to be there. So I think there is a very significant question about what aggrieved means. For example, in a lot of the cases that we have right now, the named plaintiff does not even claim that they read the terms and conditions. And I think it's very difficult to be aggrieved if you've never read it. Because you can't have been dissuaded in your ability to, and I'd be curious to see whether Joe and I agree on that point, that it's very hard to say that you've been aggrieved and you've been in the sense of being dissuaded from potentially bringing a claim if you never read the contract. But I worry a little bit. I mean, there was the Candelario decision that we'll talk about. We're gonna have some different outcomes in the district court level. And then the rubber's really going to meet the road at the Third Circuit. And I think we could have some victories because some judges say, get out of my courtroom on some cases that kind of don't belong there. And then it's going to get to the Third Circuit, and the Third Circuit or the New Jersey Supreme Court in the cases before it are going to give us some news we don't want unless we're kind of litigating these cases with our eyes open toward what the legislature very clearly intended, which I think is much closer to Joe's view of the world than it is to some of the things I've seen in some of the briefs.
Yeah, so Jeff's given an example of what would be considered sort of a clear violation. Another in the self-storage context might be a provision in a self-storage agreement that says, we, the storage facility, don't owe you any obligation to actually take care of the things that you store here. We disclaim any obligation to exercise reasonable care to make sure that somebody doesn't break in and steal your things. And if, by the way, they do come in, notwithstanding the fact that we were negligent and didn't provide reasonable security measures, if they break in and steal your things, we'll be liable only for $50, not for the actual value of your belongings that were stored here and stolen. So those are examples of potentially what would arguably be clear violations. But what we're seeing, I think, anyway, in this recent spike in cases is something that may not be as clear, and they're interpretations of terms and conditions that are not direct quotes from terms and conditions. They're usually appearing in the form of some modified reading, some modified interpretation, some, what I would argue, twisting of the language in a website term of use to suggest that it says something that it doesn't really say. Zane or anybody else, do you guys want to comment on how that fits within this context of aggrieved consumer? I mean, is there any requirement that the business have actually tried to utilize a term in the way that the plaintiff is hypothesizing it could be used in order for there to be a tickler violation?
Well, unfortunately, that requirement doesn't exist. But I think this, if we focus on the website terms of use, at least initially, because that's what the wave of this litigation has been in 2016, and that's really the focus of the plaintiff's bar. I think you have to make a distinction between what type of website you're dealing with, and I think there is a line there. There is a website that is a traditional website that you're not making e-commerce purchases from, that you're visiting, to learn information from, to view. I think in that sense, the website terms of use do not fall under the definition of a consumer contract, and they would fall outside those websites, and those website terms of use would fall outside of the purview of TCCWNA. I think where it becomes gray is when you have an e-commerce website where people do make purchases, and those terms of use are governing those purchases. And if those terms of use are trying to govern the rights of consumers with respect to purchases they make on the website, then they are going to fall under TCCWNA's, under TCCWNA's purview. So I think that's it's a gray area, but I think you can have website terms of use that are clearly outside of the intention of this statute, and where you clearly have consumers who, one, have not read the terms, and two, have never made a purchase. And being a consumer contract is something that the Appellate Division and Harrah's put some meat on. They said, this piece of legislation is here to govern consumer contracts, contracts made with consumers, and I would argue during the acquisition of some sort of property. Harrah's put some meat on the bones that means something. And I think with a lot of website uses, you could not have a class of website visitors who would fall under the Act. At least that's where I would
If I could
Go ahead, Joe.
just
Yeah.
briefly comment. So there's a bit of irony here from my point of view. This is the second time I've been asked to speak at this organization. I know Alita had asked the first time it was on arbitration. So when a case comes to my office and we're looking at whether we want to bring a suit on behalf of that plaintiff, the first thing we do is look at whether there's an arbitration clause. And very often these arbitration clauses are contained in these very terms and use agreements that we're now hearing from the defense bar aren't really consumer contracts. So I think that there's a bit of irony there. I think that Zane has split the hair perfectly. I think that a lot of the websites that deal with e-commerce, those terms and conditions clearly fall within the definition of a consumer contract. But there are also other cases where you go onto a website, it says this website is owned by subsidiary X, which is the web designer of the underlying company. But in order to get to the product, you have to get through that website. And there's no other terms and conditions. And there is where you sometimes see an arbitration clause. And guess what? If there's a clause that says I have to arbitrate, no one's going to argue that that's not a consumer contract. So there's a little bit of an irony there, a little bit of, you have to fight this statute. It has broad implications, but in doing so, I think you might be opening yourselves up to whether these arbitration clauses in those terms and conditions are valid going forward.
Oh, my heavens, I agree with that, too.
All right, you're off the panel. Joe Fischetti, I want to toss this one to you in a moment. But, we've been talking about TCCWNA specifically. These cases don't normally get brought as one-off, what we would call a one-off case, a single plaintiff, single defendant, where they're looking for their actual damage or their $100 remedy. These get filed as putative class actions. And Joe, can you talk with the audience a little bit about, whether, this idea of a statutory remedy and recovery of $100 per violation is really suitable for treatment in the class action context, and talk with us about the requirements for class action certification, whether it be superiority or ascertainability, or whatever the case may be.
Sure. I think, as a threshold matter, which is there has been, there is a 2009 Appellate Division decision that affirmed TCCWNA statutory damage claim on a class basis. So at some level, as a matter of law, yes, it is, the fact that it's a statutory penalty in and of itself doesn't preclude TCCWNA claims being brought up as a class action. But there have been some suggestions subsequent to that may not be the case. There was a 2011 TCPA, Telephone Consumer Protection Act case, where the Appellate Division suggested that statutory penalty cases are not good candidates for class actions. The court said class actions are generally appropriate where individual plaintiffs have small claims which are in isolation too small to warrant recourse to litigation. But the court said that by imposing a statutory award of $400, a sum considerably in excess of any real or sustained damages, Congress has presented an aggrieved party with an incentive to act in his or her own interest without the necessity of class action relief. And it affirmed a decision by the trial court saying plaintiff simply can come to small claims court, file a complaint, get your statutory penalty, and that's a far superior method of vindication than class action. I suspect that that is probably what was envisioned when TCCWNA was put into place. The legislative history is silent on class actions, but I do think that it was probably much more contemplated as a defense and to be used as a defensive mechanism. What most of the early cases...
Because there's rescission in it. I mean, that's important too, is you can rescind the contract. And
Right,
that's an
there is
important-
rescission under Section 15. And what you can do is, and most of the early cases were a company trying to enforce one of these provisions. And then how TCCWNA would come in is, okay, no, not only is this unenforceable, you're not just going to get kicked out of court for trying to enforce it, but there's also an affirmative claim by the consumer against you for your having attempted to bribe and recovery of attorney's fees. I think that was what was more contemplated than the class action device, and where the class action device gets most sticky is when there are counterclaims, I think, and that's when superiority can really become an issue, especially because damages alone will rarely defeat damages issues alone will rarely defeat class certification, but when you've got people, the recovery is $100 or actual damages, and there are cases sometimes where you can have more than $100 in actual damages, and then you've got a lot of individualized questions there when the actual damages exceed the statutory penalty, and those are the cases that really stand out as instances where I think that the class action device is ill-suited for these types of claims.
Zane, I'd ask you for your perspective on this, and just by way of background, Zane was part of the team at McCarter that submitted an amicus brief to the New Jersey Supreme Court just recently in two different TCCWNA cases, the Dugan versus TGI Fridays case and the Bozzi versus OSI restaurant case, in which we make this superiority argument. Zane, do you want to talk a little bit about your perspective on that?
The argument there is that when you're dealing with just a statutory violation on its own, without any actual damages, that a TCCWNA class is never superior. And the reason why is the unintended consequences. I think that's a theme that we've heard today from the earlier panel and today, is that when you're dealing with a class where there is no harm to the consumer beyond the statutory violation, there is no bad act by the defendant, you end up with statutory penalties under the Act that can be catastrophic to those businesses. They can destroy those businesses. And that's something that I don't think the legislature intended with this. I don't think it's appropriate under the superiority requirements. And there's other means, whether it's small claims court, to get redress for that individual consumer beyond just the class action.
Thanks.
Joe. We have to be mindful, though, that in the last term, the Supreme Court in Spokio made some observations, and it held that intangible injuries can be concrete. And so this is a statute which I think exemplifies where a legislature created an intangible injury. And I don't see any reason why the class action rules, whether in state or federal court, wouldn't apply to TCCWNA. I understand the superiority arguments. They've been made often in the consumer fraud context, and in that context, they've generally been shut down. The argument that, hey, you have an easy access to $100. But I think I understand where you're going, and I think the reason is because a full frontal attack on the statute is very hard. I think that the language to me is very clear, and I understand that it's necessary to come from different angles, and that's what we're doing in those amicus briefs. And I'll say this, in New Jersey, where we have the ascertainability issue in Carrera, I would not draft a complaint where mere exposure is what I'm seeking. I don't think that I would want to put the financial viability of my firm behind prosecuting that case, because I don't know how you would be able to feasibly determine who was merely exposed. So I would couple, if I'm drafting a complaint, exposure with with an actual purchase, but that's on the class
Yeah,
action.
I mean, so when you're talking about mere exposure, you're talking about potential class, because some of these are pled this way, where you've got a class that's pled as anybody who's ever surfed the web and looked at the terms of use on this particular business's
That's the Rip Curl
website.
case.
Yeah.
Right.
Right? And
Right. So in your view, ascertainability in those kind of cases would be very difficult.
in New Jersey, I'm just saying I wouldn't do it because of the challenges that I would have to face in getting past that hurdle. I'm not saying it can't be done, but my view is that you'll see decisions like Rip Curl where they define the class as anyone in New Jersey who was exposed to the website.
Right. And just, I mean, practically speaking, how do you ever identify who those people are? I mean, Carrera says you can't just self-report that you're a class member. We can't just take your say-so for it, as the Third Circuit said in Carrera. So aside from that, how do you identify who these people are who may have looked at your website? It's not like you can look at the weblog and identify a person by name and address who looked at the particular terms of use, or at least clicked and opened the terms of use on your website. So that's another potential challenge.
And just to add there, I mean, if you look at the reported decisions involving the statute, and there are not that many, but there are enough, they almost always involve someone who made a purchase. I mean, the idea that a prospective consumer can bring a class action and recover under this act, it's something that's just never been realized. Now, whether there could be a situation where a prospective consumer has his rights violated in a way that falls under the act, that situation could exist, but in reality, it's something you just don't see in the case law, and I don't think the courts would support it either.
Joe made reference, and a couple of others have made reference to the Spokio decision. And Jeff, I want to ask you to chime in on this one. Why don't you give us a little background on what Spokio is all about and how it fits in with this whole concept of TCCWNA claims?
Sure. So, I mean, over the last X years or so, we've seen a number of federal class actions where the plaintiff suffered no damages. They're looking at a statute, they're saying, you violated my statutory rights. I was not really harmed by this, but the statute says I get, in the case of the Video Privacy Protection Act, $2,500. In the case of the Telephone Consumer Protection Act, $500 to $1,500. I mean, there are these statutes that provide for significant statutory damages, really whether you suffered any damage or not. The Supreme Court took a case a couple of years ago and then denied cert as improvidently granted. That was sort of, okay, we're going to get the decision now, and they didn't. And then Spokio came along, and I happen to know the plaintiff's lawyer in Spokio very well, and he and I talked about this a number of times before the Supreme Court argument, and neither one of us thought that we were going to get that great pro-defense or pro-plaintiff decision. We kind of thought that the Supreme Court was going to duck, and they largely ducked. And what they said was, look, you can't just say, I read this statute, you violated my right under this statute, and I get money. If that's all you got, you're out of here. There's no Article III standing. There's no, for the non-lawyers, there's no case or controversy. That's just a pure gotcha, and you don't have enough of a personal stake in that to be able to come to court and sue. On the other hand, if you suffered concrete, particularized harm yourself, you have a claim. Now, rubber meeting the road here. So, for example, in the Telephone Consumer Protection Act, it says you can't call a mobile phone without prior express written consent if you're using an auto dialer. That's an oversimplification. But so, okay, my cell phone rings, and you use an auto dialer. So do I get the $500? Well, if the phone rang, that's one thing. Right now my phone's on mute, so I don't know that the call came in. Am I aggrieved anymore? I don't know. These are all questions that need to be taken up by courts in due course, and we're starting to see decisions all over the place in Spokio. But the TCCWNA falls into a particular category of statutes, and I'll try to be a little bit neutral about this just to present it down the middle. But basically, here the injury is informational. It's similar to the Video Privacy Protection Act. If you're a video provider and you share information about what videos your customer watched, the customer is injured by virtue of the sharing of that information, regardless of whether he's Judge Bork, who had his video history displayed on the front pages of the newspapers. And so Congress intended to create that informational injury, or so argue the plaintiffs bar. And so therefore, Spokio does not require that they suffered some out-of-pocket harm beyond the mere sharing of that information. So the Spokio argument with regard to TCCWNA is, do I suffer a concrete and particularized injury simply by virtue of being we'll leave the prospective consumer to the side for a minute, that if I signed a contract that contained a violation of a clearly established right, have I suffered harm right now, right then and there, simply by virtue of I signed the contract and I think I'm giving up a right that I'm not actually giving up? Do I need to wait until I have experienced a problem and now I've been dissuaded because the contract says so, or do I need to try to enforce? I actually have a claim and I'm now going to court to try to rescind the contract. What of those three situations gets me over the bar of Spokio? And I just want to take 30 more seconds and then ask my colleagues what they think. You've got the statutory requirement that you be aggrieved. And we're going to disagree about what aggrieved means. It means something. You can't write that word out of the statute any more than you can write any of the other words out of the statute. And so aggrieved has to mean something. And I would argue that at the very least it means you've got to have read the darn thing. And so the people that are bringing the terms of use cases without being able to say that they read it before making the purchase or really ever read it, they ain't aggrieved. But what I'm troubled by is some people have decided to argue that Spokio requires something more than the statutory definition of aggrieved. And the problem with that is if you win on that basis and you say, all right, you're out of federal court. So I got into federal court because this is a class action pleading more than $5 million in damages. So I'm in federal court under the Class Action Fairness Act. But now I'm arguing I don't have Article III standing. Welcome to the warm bosom of state court, which maybe you want to be there, maybe you don't. I mean, I had the privilege of litigating before judges all over the state when I was director, and there are some wonderful judges that I would love hearing these cases. There are some other places I don't know that I would want to be litigating a TCCWNA class action. So I'm troubled by the Spokio arguments. I worry a little bit about us on the defense side trying to say that Spokio has a hurdle higher than what it means to be aggrieved, but I also recognize that I'm a little bit in the minority on this. I think I may be the only person who's filed a TCCWNA brief that hasn't made a Spokio argument, which I'm either brilliant or an idiot, and I don't think there's a middle ground. So
We haven't for that exact same reason.
Okay.
You end up in state court if you
yeah.
I mean, I would argue that a lot of these cases are going to be in state court anyway. I mean, I think if the courts looked at CAFA and tried to enforce it in any sort of meaningful way, a lot of these websites, you're dealing with a small purchase population in New Jersey. If you take out the prospective consumers and deal with actual consumers with just a $100 violation, I mean, I think ultimately state court is where a lot of these class actions are.
Well, but right now you've got Toys R Us, Bed Bath & Beyond, Walmart. They're going to be in federal court. I mean, we got more than 50,000 customers, and so I mean, I don't disagree with you that there's some of the cases are against smaller entities, but they're going to be enough that'll stay in federal court that we're going to get some federal guidance here.
I even think some of those, I mean, there could be a home state exception on some of those as well. But yeah, I mean, there will be some in federal court. I think you got to, win your battles. I think Spokio does have some significance, especially dealing with claims that are not, these aren't meritorious claims. I mean, we're dealing with a plaintiff's bar that's driven by, no offense, they are economically driven. They are there to recover. No. and their business model, I think, is not, I think state court presents for out-of-state plaintiff's bar, and that's a lot of the people who are bringing these claims. I think state court class actions become far less economically interesting. They can monitor their cases easily in federal court. They have an electronic docket. They don't have those benefits in state court. They have to get somebody on the ground. They need boots on the ground here. They need a plaintiff's attorney in New Jersey to help them file things, and I think that becomes just a tougher sell from a business model perspective. So I would do everything I can to get them dismissed in federal court.
Jeff, let me ask you a question back on what you were just commenting on. I mean, is it your argument then that the aggrieved consumer language in TCCWNA is essentially the same thing as Spokio?
Yes. I mean, the short answer is that if I was wearing a black robe here, I would find it hard to say that plaintiff in my court is aggrieved under TCCWNA, but nevertheless lacks the concrete and particularized harm under Spokio to stay here in federal court. So again, I don't know what aggrieved means. I'm dying to know what aggrieved means. I mean, there are all of these, and I've read all the briefs, and with some wonderful lawyers who have filed these briefs and made very, very creative arguments about what aggrieved means, and we're going to start seeing answers to these questions, but from both state and federal court. But I find it hard to imagine a set of circumstances in which a judge answers the aggrieved question affirmatively, but then nevertheless says, and by the way, it goes back, and this is, we mentioned earlier, TCCWNA doesn't create any rights. So in other words, sometimes you see TCCWNA as an add-on claim to a Consumer Fraud Act. So that in other words, you harmed me. I paid money out of pocket for this product. And by the way, I've also got a TCCWNA claim so that I should get $100. That's a different circumstance here. What we're mostly talking about is, I bought the product, I was happy with the product, I got exactly what I wanted, but by the way, the contract that you sold the product to me on violates my clearly established right, so I'd like to keep the product and my $100, please. And I think if you're aggrieved, you probably are in the door on Spokio, but there are people arguing differently, and I'm dying to see the answer to that question. I have chosen not to make the argument simply because, as Joe just said, I like litigating these cases in federal court. I like, if I have to deal with class certification, I like 23F. I like being able to go to the Third Circuit on an interlocutory basis. I don't really want to be in state court on these things. But that's why, tactically, I didn't think too hard about arguments I might have made, but other people have made them, and that's why Baskin-Robbins makes 31 flavors. We're going to see.
Yeah.
We're going to see what happens.
And I guess that also, standing is obviously a preliminary issue that a court's always going to need to deal with. And Spokio, certainly for those in the legal community, has gotten so much attention that I think it's impossible that our federal judges in this district or any are going to ignore the existence of Spokio in the context of one of these no-injury class actions under TCCWNA.
No, that's right, and so they have to deal with it. But like I said, if you take the position that aggrieved and concrete and particularized harm are one and the same, you end up in one place. There are dangers to that. In other words, if you're admitting that the person has concrete and particularized harm, if they're aggrieved, then you are disarming yourself of a potential weapon. But again. Look, I mean, the Candelaria case that we just got that's in your materials that was decided in California very recently, they basically said it's the third example I mentioned, that until you actually have a claim that they've injured you, and now you're trying to assert your right, and you're going into court and saying, but the contract purports to exclude me, you need to actually have an accrued, Uncle Joe slipped and fell, here I come. I think that has to be wrong. And so I don't know what's going to happen to that decision, but now that decision has been put in front of the New Jersey judges with notices of supplemental authority in all these cases that are pending. And my opinion doesn't matter. I mean, it's all about what the judges say. But I mean, I really worry about the defense bar trying to hold that thing up as let's adopt this in New Jersey, because I don't think the judges in New Jersey are going to look at that decision and say that is consistent with what our legislature wanted. And even if it does, and even if that's what Spokio means, that cause of action gets litigated in state court, and I know that's not what the state judges are going to say it means. So, I don't know.
Interesting. Jeff, another question for you, a slightly different topic. We've talked about the clearly established legal right concept. We've talked about how that clearly established legal right could be a statutory right. It could be a right that's provided under administrative code. It could be a right that arises under the common law. But let's talk for a moment about statutory rights of consumers. What if you have a situation where a consumer has a statutory right, but the legislature has decided that if there is a violation of that statute itself, it specifically writes out a private cause of action. In other words, it says this is illegal, businesses can't do this, but we don't want private attorneys general running around the state filing lawsuits over it. We're going to vest exclusive authority in the attorney general, or maybe even it's silent as to that, but it writes out a private cause of action. Can that type of statutory violation, in your view, still give rise to a TCCWNA claim?
I worry that judges will answer that question yes. And I think that would be an unintended consequence that the legislature would want to get involved in. Because I think that what if you look at TCCWNA just within its four corners, it says, "Thou shalt not give a contract to someone that violates a clearly established right." Now, I mean, I think you'd have to be hard-pressed to posit that kind of a right that the legislature did not give a private right of action with respect to. So in other words, I've racked my brain trying to think of an example that I'd be able to say, okay, I've got the one where that thing can be violated and there wouldn't be either a private right of action under that statute, and then I would be able to make a cohesive argument that you don't have a TCCWNA claim either. I mean, even in the pet example that I mentioned earlier, there's a rescission right. The consumer can come back and basically return the dog. And so, you know, I don't know. I think that I certainly would want to reserve the right to argue on behalf of a client if somebody finds the example that the legislature in its wisdom did not want there to be a class action here in court over this, and you should not be able to get in the back door by TCCWNA. But frankly, look, I think the one thing I think we all agree on, plaintiff, defense, law enforcement, I think we all agree that clearly established is the main event here. I think a lot of us are arguing that and the example that I agree with completely of, you know, you can't misinterpret these terms of use. You can't sort of hold them up to the light and say, well, if I squint really hard, I can find something in here that you might interpret this way. And if we win on that, if courts say, no, it's really got to be a right down the middle, you're violating my right, the Supreme Court has said it's a right, this contract, anybody should have known you can't put that in the contract. If that's what clearly established means, a lot of these other battles kind of fall away. Because then you're talking about a narrower set of rights that can be vindicated in the statute, and it becomes easier to see who's aggrieved and what this all means. But these gotcha cases, I can't believe the judges like them. It says nothing good about New Jersey, that we're the only state that's got one of these things. I mean, California's got its own problems with internet commerce, and by the way, in terms of the constitutional arguments, dormant commerce clause is another great one, when you're basically trying to regulate the internet from one state legislature. But we gotta deal in a mature way with some of these gotcha cases in TCCWNA, and I really hope we talked, getting ready for the panel, we were kind of hoping we would get a couple of decisions last month, because they've all been sub judice for a little while now. Any minute now, we're going to start getting some guidance, and we're either going to say, yeah, that makes sense, judges are doing this the right way, this is going to come out all right, the legislature doesn't need a ride to the rescue, or we're going to start seeing real problems, and then all of you, from your various perspectives, ought to be saying, Alito, what the hell are we doing? And then go into the governor's office and go into the legislature and say, now you got to fix it because this is not what we intended. So, I don't know.
It's sort of a related question and maybe less theoretical, because we see it in cases, at least historically had, is situations where plaintiffs will plead both a New Jersey Consumer Fraud Act violation and a TCCWNA claim. It used to be that the tip of the spear was the CFA, and maybe it still is in most cases, but certainly in the TCCWNA context in the last 12 months, we've seen these TCCWNA-only class actions. But in a context, I'll toss this one to you, Jeff, first, and see if anybody else has any comments. But in the context of a claim that's alleging both a Consumer Fraud Act violation, which requires that the consumer have an ascertainable loss in order to bring that claim. If you have a situation where the consumer's pled both a CFA claim and a TCCWNA claim, and there's no ascertainable loss, I mean, do you have an opinion on whether the consumer could still then advance the TCCWNA claim in the absence of the ascertainable loss?
Not for violating the Consumer Fraud Act. That, in other words, that the Consumer Fraud Act claim would be. Are you hypothesizing sorry to answer a question with a question. Are you hypothesizing a Consumer Fraud Act claim based solely on the wording of the contract?
It could be either. I mean, in my hypothetical, it could be either you've got a violation of the CFA itself, or a violation of some other administrative code provision or what have you gives rise to a claim under both the CFA and TCCWNA. All
right. So look, I mean, if you're talking about I'm saying that this is what you gave to me is I guess in some of the restaurant cases where the menu says one price and you charged me another, and so therefore you violated both the Consumer Fraud Act and then TCCWNA. My guess is these things are going to turn out to be one or the other and not both. But I think that if you have no ascertainable loss under the Consumer Fraud Act, but the thing that you're suing over is nevertheless a notice or a warranty or a contract as defined in TCCWNA, and it violates a clearly established right, there may be a way for a TCCWNA claim to survive there, but again, it's going to, now I'm sort of wondering what what could the clearly established right be that gets you over the TCCWNA hump, but yet the Consumer Fraud Act didn't get you there. So I probably, as somebody smarter, could come up with an example that satisfies it, but I haven't been able to
Zane,
figure it out.
come on.
You know, I was just thinking, I was trying to think of an example. I mean, I do think you could have it. Again, it's the question of, you know, you can have a CFA violation without an ascertainable loss, and then that be the basis of your
Right.
TCCWNA. I could conceive it, but again,
Yeah.
coming up with the scenario where that happens is a difficult one.
And the reason that's so is because under the Consumer Fraud Act, the Attorney General can maintain an action even where there's no ascertainable loss.
And they do.
And they do. So, and we all know that. So to, you know, to look at it that way, the clearly established right may vest in the Attorney General to bring it, but it still exists. The consumer still has that right. The Attorney General could bring that case. I'll say this, though. Judge Wilson, in a recent opinion, if you want to read it, she mentioned that this issue in federal court is less clear, and in the footnote, she set forth cases that are on both sides, and that's the Trullo versus Planet Fitness case, Trugglio versus Planet Fitness. And you could read that and look at how cases in federal court have come out on both sides of the issue.
Couple other questions, unless we have any from the audience I wanted to throw out there. We've talked a little bit about Section 15 violations or Section 16 violations. Remember, Section 15 is the operative portion of the statute that talks about clearly established legal rights or provisions in contracts or clauses and notices that violate a clearly established legal right or responsibility of a consumer. And then Section 16 has in it this funky language that I think is unique to New Jersey about this void where prohibited. We've all seen these void where prohibited clauses in various contexts, but Section 16 basically says that you can't put in a void where prohibited clause, except in a warranty. You can't put it in a notice or a contract that says void where prohibited, but doesn't specify whether the affected terms are enforceable in New Jersey or not.
And by the way, the reason why you can't do it in a warranty is because federal law says you can.
Right.
The regulations under the Magnuson-Moss Act say that you can say some states do not allow limitations on the duration of certain warranties, and so you can use that language in New Jersey. It came up as an amendment during the enactment process. Whoops, can't violate federal law, so they said that Section 16 does not apply in the case of warranties, and in the case that I'm defending, we made that motion to dismiss, and the plaintiff came back in the opposition brief and said, whoops, and dropped the claim. So.
Well, it's funny you mentioned, in the Symphony case that Zane worked on and got dismissed, I mean, there was a unique situation in which the plaintiff's attorney in that case had pled a Section 16 only violation, but no Section 15. So said there was language in the website that said void were prohibited, but didn't identify any clearly established legal right under Section 15 that had allegedly been
And
violated.
that's right, and I think this goes back to what the purpose of Section 15 is, and that is there's got to be a clearly established legal right that's violated, and that's where the statute kind of starts from. So to have a Section 16 violation where you're saying you need to tell us what is unique about New Jersey law, but not identifying anything that violated New Jersey law, we argued is that cause of action can't exist. I think you have to have a Section 16 where you identify a clearly established legal right that violates the statute, and then you can bring a Section 16 violation, which basically says you didn't tell me that this was not valid in New Jersey. So having the Section 16 on its own, I think is a tough sell.
Especially because I think when you look at Section 16, it becomes pretty evident that it's meant to avoid an easy end run around Section 15. And so to then kind of have it be its own independent cause of action with no actual unlawful provision is an odd result.
And we know that because the legislature said so. I mean, in other words, what they said was is we want to prohibit you from including a violative term, and then and it says in the legislative history very clearly we want to prevent you from getting around this by saying well, here's this violation, but it might not apply in some states. And so that's exactly what it's intended to do. And I agree completely that a Section 16 violation, absent some clause in the contract that the plaintiff points to and says that violates New Jersey law, that it can't be an individual violation because they're not telling you what am I supposed to do in this contract to fix it? Because I can't tell you what violates New Jersey law because nothing does.
We all agree. Joe, do you agree? Let's get you on.
No, but why not?
That issue is before the court, I think, in the Heck versus Hertz case. There's a lot that was briefed on point, and I think the lawyers there on the plaintiff's side have argued that Section 15 and Section 16 are independent of each other, that you can have a Section 16 violation. The two provisions are different. Clearly established doesn't exist in Section 16. It does in 15. There's warranty provisions that you could have in 15 and not in 16, so they're not to be read together, but we'll see what the court does with that.
I'm going to ask a question that maybe nobody's going to want to answer. Without revealing client confidences or attorney work product, does anybody want to talk about what to do? I mean, for the business people in the audience or who may watch this later on video, I'll remind you we are being taped. What do you do if you get one of these demand letters? I mean, what we've seen are literally a blizzard of demand letters that have gone out to businesses all across the country saying, you know, I have an unidentified client who went on your website. Maybe they purchased something, maybe they didn't, and they were exposed to a term that we interpret as offending TCCWNA. And we've done some Google analytics that suggest that there may be millions of people, or at least hundreds of thousands of people who may have been exposed to that, have seen that provision, and therefore you're potentially eligible for millions of dollars in damages. Please contact us, the lawyers for the plaintiff, about an amicable resolution to avoid us filing a lawsuit. I mean, what do you do in that situation if you're a business person? Anybody want to take that one? Or are you going to save that for when you're actually being paid?
I'll take it. I'll take it. If you haven't been served with a complaint and you've only received a claim letter, so this is the potential of a lawsuit, my recommendation would be to do nothing. And do nothing means not just do nothing, but do some due diligence, figure out the size of the potential class, do some investigation on your sales in New Jersey during the alleged class period. But there is so much case law outstanding. There are going to be decisions that are going to come down, hopefully by the end of this year, that will hopefully provide some limitations on these claims. That right now, I think the best thing is to just kind of wait and see. And if plaintiff files, but they are busy and they've got a lot of other buns in the oven. So I would do nothing with respect to the claim letter.
I mean, what about the idea of taking them up on the offer to talk about an individual settlement? I mean, does anybody want to talk about that, Jeff, Joe, or Joe for that matter? I mean, is that an exit strategy that would give the business any protection or comfort if you take that bait and discuss with that plaintiff's attorney some type of one-off individual settlement for that particular claim?
We know it is an exit ramp because some of these cases have gone away, and I don't think they went away because the plaintiff changed his mind.
And they often go away for less than the cost of litigating it, like significantly less. I think the question is, as you referenced, when the sweet spot is to actually start entertaining that.
I mean, I don't disagree with Zane at all. I think that when you get one of these demand letters, the first thing you do is what you do in any case where you get a demand letter, which is investigate the facts. And what does what does my contract or my notice or my warranty say? Do I think that it violates a clearly established right in New Jersey? If it does, I've always counseled people to fix the problem. I mean, even though it could be potentially impactful in the problem you now have, it's kind of better to stop the bleeding and fix it and then deal with the retrospective lawsuit subsequently. On the other hand, if you think you haven't violated a clearly established right and you think that you haven't done anything wrong here, guidance is coming. And I'm not in a. There are a lot of cases where, I mean, if somebody wants $1,000, pay them $1,000 because we're going to spend $1,000 opening the envelope. But they're not looking for $1,000, and I would not be in a huge hurry to resolve something on an individual basis that can then be replicated by the next person. If I did something kind of a little bit wrong, I fix the problem, maybe think about settling it individually. If I've got a bigger problem out there, you fix the problem and you do something else. If you don't think you have a problem, I don't like, negotiating with people who I don't think have a claim and are just trying to.
Right, because, I mean, even if you look at it from a business perspective of what's the cost going to be to, let's say, file a pre-answer motion to dismiss, and I can settle the case for less than that, with this one individual, you're not getting protection from copycats, right? I mean, you
Right.
can't use that settlement to say, look, I fixed the problem, I settled, and therefore this next plaintiff who comes down the pike, maybe even represented by the same lawyer, has no claim against me and can't sue.
But if you look at the docket of cases, I think basically businesses are reacting the way you would want businesses to react. Some of the smaller shops are saying, get me the heck out of here, and paying a little bit of money, and the Toys R Us's and the Walmarts and the Bed Bath & Beyonds and the Hertz's are fighting. And they're going to set the law, they're basically going to say, look, we're going to spend a little bit of money here to try to set the law on the right course.
Do we have, we're nearing the end of our allotted time. Does anybody have any questions from the audience? No? Yes, over here.
So thank you guys. It's really great to hear. Thank you. This has been really great. I do have a question. I mean, it's really clear that there's a lot that's unsettled and there's going to be some guidance coming. As a person who works for a company and is trying to help chart these waters, what is the advice to take now if there's no claim letter? We're not at that place yet, but we're trying to fix things or assess what to do. What's like the practical advice for companies right now trying to figure out how to navigate in very unclear water regarding things like terms of use and transaction terms and how they work together?
Do you want to take it first? I've got it, and then I want to.
I would proactively review your kind of consumer contracts, whether it's your website terms of use, whether it's, I don't know what the industry is, but if you do have contracts that are given out to your consumers, I would review those. I also think with respect to website terms of use in particular, it's a really less is more. In doing this work, the number of companies that I've heard have ever affirmatively relied on their website terms of use in a case is zero. I've never seen a company use them in any sort of affirmative way.
Use them all the time. That's why I agree with Joe.
But I mean, so I think you just want to less is more. Figure out what exactly in those provisions mean something to the business. Often they're out of date. They contain provisions that deal with promotions that are years old and are no longer valid. So just be proactive in making sure that they're current and reflect your business needs.
I would add to that two practical pieces of advice. The first is a lot of the lawsuits that have been filed have been focused on the clearly established right to be able to assert tort claims. And what the plaintiff's bar is trying to do here is they're looking at disclaimers of liability, and they're really over-interpreting them to say you're trying to get out of your own negligence, you're trying to get out of your own intentional torts with this. And if that's not your intention, if you've got a disclaimer of liability in a contract and it's not your intention, there are ways to tweak the language of that in order to make it very hard for somebody to turn it around on you. The other piece of practical advice regards Section 16. What you can't say under Section 16 is some states don't allow this prohibition. What the courts say you can say under Section 16 is to the fullest extent permitted by applicable law. Now, what's the difference? Courts say it's different, so it's different. And so you are allowed to say to the extent permitted by applicable law, which means that you are trying to get the broadest disclaimer that is available to you in whatever jurisdiction the contract is applied in. That neither violates Section 15, because if it ain't enforceable, it ain't enforceable, nor does it violate Section 16, because courts have said that to the extent permitted by law is not a Section 16 violation, because it doesn't fall within the narrow band of what Section 16 prohibits. So those are two things you can do as you're looking over your contracts and notices and warranties.
And I would add to look at the sponsor statement that that's attached to the bill, because it sets forth a bunch of examples of what the sponsor stated and what the legislature says is
Yeah.
violations that violate clearly established law violations. I'd also say, look at the case law. When you see the provisions that come up time and time again, probably 99% of the time, broad liability, limitation of liability clauses, or assumption of all risk clauses, release of tort liability even for intentional acts. The Supreme Court very often has spoken on all those, and they talk about that these are well settled or that they violate public policy. And whenever you have a clause that's well settled, violates public policy, tweak it. That's what the intent of the statute is to have businesses look at their contracts and take out offensive language.
I agree with that too.
I think everybody agrees with that.
Yeah, we all agree.
Yes, in the back corner.
General come out with any kind of do's and don'ts for businesses, so you don't have to hire a law firm and a business can go online and sort of find out what are appropriate terms of use and just get general business advice?
Not to my knowledge. So, I mean,
If they should or shouldn't, or what's your thoughts on that?
I will confess that I had not heard of this statute until a wonderful lawyer named Lorraine Rack, who was the section chief of the Consumer Fraud section of the Division of Law, kind of walked into my office and gave me a tutorial on the law. And the Attorney General's office has made some statements in briefs about what it thinks the TCCWNA means. It's an interesting question, and I will call my friend Steve Lee, the Director of Consumer Affairs, and ask him whether he has anything in the hopper, because it is a good idea. The Division of Consumer Affairs has typically put out consumer advisories more so than business advisories. But the one thing I'll say is that, TCCWNA is of great concern to businesses large and small all over New Jersey. And this is a problem that, depending on how judges rule, can be solved with a statutory amendment, although that requires the consent of the legislature. It can be solved to a degree with regulations, which is something that, although the legislature can override it, it's an executive purview. And, this is simply a matter of personal opinion. I have not been in the Attorney General's office for 6 months, and I will not comment on conversations I've had with my former colleagues since I've left. But, for those of you who want to see changes made here, Assemblyman Scher mentioned that Ambassador Murphy looks like the presumptive next governor of the state. If you want things done regulatorily, look at the calendar, look at the clock, and make phone calls, because that opportunity is not going to be around forever, if you believe what Assemblyman Scher said.
One other thing is that what is a clearly established legal right is something that's always going to be in flux. I mean, there is never going to be, as new cases come out, and TCCWNA can come from both case law and statutes, as new statutes come out, that bar is always going to be moving. So it's something that you have to stay, abreast of, because there isn't going to be a black line where your terms of use are perfect today. They may not be perfect
Just as an example, I mean, I have young girls, and they go to these trampoline places that are all over New Jersey, and the APTIV came out with a decision about 2 months ago saying that the waiver that we all have to sign for our kids that says, when they get hurt, you can't sue. The APTIV just said that those are unenforceable, because you can't foist onto the state the cost of caring for your child. Now, it's an APTIV decision published. Is that clearly established law? Because the New Jersey Supreme Court theoretically could grant cert and reverse it? I don't know. I mean, it's there, it's published, it's binding right now. I would certainly be listening to it if I ran a trampoline place, but,
I think Joe would definitely argue it's...
I'm sure he would.
legal right.
You need a lawyer, Jeff?
My girls have all escaped from those places unharmed so far.
I think we have time for maybe one more question, if we have any from the audience over here.
And Apple recently submitted a brief that challenges the constitutionality of TCCWNA based on the Dormant Commerce Clause. I wanted to ask the rest of the panel Does anyone think that argument has merit or not?
I do, big time. I think that when a state tries to make I made the same argument in California against what they call the shine the light law, and the plaintiff backed down and took a really cheap individual settlement. I never got to argue it, and I regretted it. But I think that basically what Dormant Commerce Clause means is that where there is a federal system of commerce, a state can't come in and put in a state requirement that then effectively becomes the national standard. And that's basically what TCCWNA means. I mean, we all represent national companies that are now conforming their national contracts to New Jersey and what is a clearly established right in New Jersey. And that can't be right. And so I think the argument, I sure am rooting for it. I know Joe's not.
Well, with that, I want to thank you all for your time, for your attention. I want to please join me in thanking our panelists for this discussion.